The nature of the offense and the circumstances under which the offense was committed are to be considered. Well, I don't see much of a worse nature of an offense. You got one person shot and killed, another shot and seriously wounded. This is, let's say, occurring at 8:38. In Alice Keith Park, a park where we're supposed to not have the shootouts at the OK Corral there, but where people can go and enjoy the park. How's that working out in this instance? Even if they were, I know it's late, but it's June 10th, which at this time it's 8:30, so it's on daylight savings time. It's still light to some degree. You're trying to look for a place for a picnic, but you've got to step over the bodies to get you to be able to roll out the picnics. And then that very nature, I mean, it's in a park, a public place for everybody to have to deal with. That, number one, is an egregious check against you. Number two is an offense involving violence. Yes, this is most violent. One person's dead, another is seriously injured. Let's see. Oh, family ties. You said that he has a child coming here.
We have a child that is here. She will be born at the end of this month.
Oh. Okay. Is family important to you, sir?
Yes, sir.
Can you explain to me how?
I do. I care for him. So I was beat up my daughter.
Oh, okay. When was she born?
Last year, February 26th.
Of when?
Of 23.
Oh, wait, she was 3 months old when you killed the guy. No, well, when you're alleged to have killed somebody, according to the indictment by the grand jury believes you did, and that you shot somebody. Why weren't you at home taking care of your family instead of being somewhere where you're accused of killing someone and seriously injured someone? Now you're a family man all of a sudden. Now it's important to you. Well, that's one of the conditions here that you look at: family ties and ties to the community. I mean, y'all want to bring it up that he's got a family, but he had a family, that an infant that needed to be taken care of by a father on the date that he is alleged to have committed this. What else? Anything?
Nothing else in the history.
I can't change that under these circumstances. What you told me are things that are absolutely refutable by the facts. This is a most serious crime. So the circumstances are bad. And then what you say about family ties, you had an infant child at home when this occurred.
Will you hand me my screen box?
Now go freak. So we're back on the record in 23 CR 372, State versus Brenna Dick. All parties as before. Mr. McGeer.
Your Honor, my understanding after conferring with my colleagues that there have been prior communications between counsel for the defense and my office. If counsel for the defense is prepared to address any possible plea, I believe I am prepared to proceed in this matter.
And I believe he indicated he was. So what we're looking at 9 counts, including 1, 2, 3, 4, 5 counts of battery of a law enforcement officer, interference, battery,
Yes.
driving under the influence, and transporting open containers. So what kind of agreement do we have among those charges, counsel?
Your Honor, my client was going to agree to plead guilty to count 1
Okay.
and count 8.
All right.
And counts 2, 3 through 7. And in addition to count 9 would be dismissed upon a successful plea. And the state would recommend a minimum sentence, probation. I've already submitted a alcohol drug eval, and she does have counseling lined up. I did not provide you a copy of that letter. It's simply a letter saying that she's going to begin counseling on February 14th to address any issues dealing with obviously anger or otherwise.
When did you send me the alcohol drug evaluation counsel?
Thursday.
Okay,
And Savannah acknowledged that she was going to forward it to you.
I do have it. Thank you. All right, at this time, that is your agreement, Mr. Regier, or the state's agreement?
Your Honor, after conferring with my colleagues, the state is prepared to proceed in that manner.
Very well. So, Miss Dick, how do you plead to count 1, battery of a law enforcement officer?
Guilty.
And how do you plead to count 8, driving under the influence of alcohol or drugs?
Guilty.
Is anyone making you enter this plea today by any kind of threats or promises other than the plea agreement?
No, Your Honor.
And do you understand that if I accept this plea, there will be no trial, you will be convicted, and you will not be able to appeal that conviction?
Yes, I understand, Your Honor.
Okay. And what did you do in count 1 that would make you guilty on July 29th of 23 of battering a law enforcement officer in Butler County, Kansas?
I caused physical contact with the deputy in a rude, insulting, and angry manner
And
Okay.
that's Butler County.
in Butler County.
Okay. What exactly did you do to him?
Well, Your Honor, it was and I can help lead her through it, but it was a
I
fairly.
just want to hear it in her words.
I know you do, Judge, but I want to explain. You haven't. I've seen the video. I know how everything went down, and
Okay.
she got upset with an officer, and then it was as typically in these cases. She was taken to the ground, and there was a lot of physical altercation. When exactly each officer was hit would be difficult for her to determine. But she does admit that she did strike the deputies in an angry, rude, insolent manner. And thank goodness nobody was injured.
Okay.
But she can tell you that if you'd like. Yes.
So that's what you did. You were kind of resisting the officers and they got punched and hit a few times while you got
Yes,
taken to
Your
the
Honor.
ground? Okay. And was your contact with the officers involving a DUI by chance?
Yes.
What made you guilty of driving under the influence?
I was,
Well, just tell her that you were driving and that you were.
okay, I was under the influence when I was driving my car.
All right. Where were you driving? What highway?
The Highway 254 in Benton.
In Benton? Okay. And what was it, alcohol or drugs that made you under the influence?
Alcohol.
Did you take a breath or blood test?
No, Your Honor.
So you refused the test?
Thanks. Yes, Your Honor. It devolved pretty quickly, unfortunately. It's a very bad experience, which I believe my client's very sorry for.
I see there's an affidavit in the file supporting the arrest. Does counsel stipulate to that?
We stipulate to the allegations in counts 1 and 8, Judge.
Okay. Looks like she had glossy, bloodshot eyes, an odor of alcohol. She turned her ignition off several times, but refused. Oh, she was told to turn it off, but refused. Her words were slurred. And when she went to get her license, she went to hit the officer with her wallet, threw a pack of cigarettes at the officer, striking him with them. See a lot of evidence about count one. Okay, it all started with the call that the female was passed out at the quick shop behind the wheel of an automobile. Left at a high rate of speed. Okay. Okay, I find the defendant guilty of counts 1 and 8. And I do have, as I said, the alcohol and drug evaluation. Mr. Regier, have you seen that?
Your Honor, I do appear to be in receipt of a document pertaining to that.
Document Kansas Client Placement Criteria Screening Instrument.
And Your Honor, one of the things, they only recommending the one-day class. I will tell you that she is entering counseling, and because obviously she did not react well when this occurred, she doesn't have a history of DUIs. She was denied diversion because of the allegations of law enforcement battery. I will tell you that she's, if required, perhaps her counselor could do an assessment and provide that to probation and make sure she gets appropriate treatment for whatever issues may have caused this event on that day.
This is a rather lengthy report, which it's always better that they do more than less, but
It's always hard to find.
it is. It's always to get to the bottom line. Summary recommendations. It is the evaluator's clinical impression that substance abuse treatment is not warranted or needed at this time. The recommendation is for ongoing monitoring for abstinence, as well as an 8-hour ADIS school, that's alcohol and drug information class, and that she have mental health examinations. So with that, Mr. Regier, the state's recommendations for plea agreement?
Yes, Your Honor. On count 1, the state is not recommending a fine, but the imposition of court costs. My understanding is that would be $158 since the information filed in this case does appear to include a case number CR. The state would further be recommending a 12-month underlying sentence with 12 months of reporting probation and a $60 probation fee. For count 8, the state would be recommending the statutory minimum fine of $750, a 6-month underlying sentence. Again, 12 months reporting probation, $6 probation fee with DUI victim panel, follow drug and alcohol evaluation recommendations with all standard conditions. I am not aware if the issue of concurrent or consecutive was discussed between counsel for defense and my office, but in this particular instance, the state would be recommending the sentences be running consecutive.
And you're saying sentences, you're meaning counts 1 and 8?
Yes, Your Honor.
Thank you. Mr. Cummings, anything additionally before I pronounce sentence?
Well, yes, Your Honor. First of all, I appreciate the state's recommendation, and I would disagree a little bit with Mr. Regier's recommendation of consecutive. That wouldn't fit in the terms of minimum sentences. I think it would be concurrent, but that's not here nor there, actually, Judge. I don't think she's going to have a problem on probation. I will like to take this opportunity to let Ms. Dick say something to the court. Thank you, Judge.
Thank you.
Yes, I just want, do I go ahead? I just want to apologize for what happened. I realized that it was a very big mistake for what I did, and I just want to say that I have great respect for law enforcement.
So are you apologizing to each of these officers that were hit, struck, and so forth?
Yes, Your Honor.
That would be
Every single one.
Okay, Deputy Ruth, Sergeant White, Deputy Baraka, and I apologize if I'm not saying that right, Barakeh, Deputy Marshall, Corporal Butcher, Captain Knapp, to each of these and anyone else victimized by your behavior that night,
Yes, Your Honor.
as well as to all of the citizens of the state of Kansas whose laws you've broken?
Yes, Your Honor.
Thank you. I appreciate that. At this time, your sentence in count 1 is 12 months in the Butler County Jail. On count 8, 6 months in the county jail concurrent to count 1. In count 1, there will be no fine. In count 8, the minimum fine required by law for DUI, first offense, is $750, and that will be the order. You will also be assessed and required to pay $158 in court costs and $60 in supervision fees, for a total of $968 if I'm doing quick math correctly. I will grant you probation from that jail time. That will begin immediately, and you are ordered as soon as this hearing is over to call and report to probation at 316-322-4153. The first order of probation is to set up a time frame for you to make the payments. Not that it's necessarily money over anything else, but that's just first on my notes. So how long is it going to take you to pay $968?
Can you do maybe 6 or 7 months?
I was gonna say at least 6 months, Your Honor.
Do you think you can pay that $968? Can you make payments on that?
Yes, Your Honor.
$180 a month, and I'll make your first payment due March 12th in 30 days, give you a little bit of time to get prepared for that. And then it'll be due on the 12th of each month thereafter. And of course, you're going to be required to follow all standard conditions of probation, which the officer will go over with you. You are to violate no laws, of course, and to be around no alcohol or illegal drugs in any way, shape, or form. You are to complete a DUI victims panel. That has to be scheduled within 14 days, not completed within 14, but scheduled. And then you will be required to comply with your alcohol and drug evaluation recommendations, which are to complete the
Yeah, that's happy, Hunter.
yes, to complete the 8-hour alcohol drug information class. And then I'm going to order that you have a mental health examination. And I want the examiner to know that you had this trouble with the officers. I want them basically to have a copy of the affidavit so they understand why I'm ordering that, and for them also to have a copy of the alcohol and drug evaluation.
Yes, sir.
Is there anything else that I overlooked, counsel?
Your Honor, insofar as the issue of reporting probation is concerned, is there a specific time length rather, that the court is ordering?
Yes, 12 months. Thank you. 12 months starting today. Anything else?
From the state, Your Honor.
Nothing, Your Honor.
All right, then we will be in recess.
CR 23, CR 2211, 2212, 2213, 2214. 2215, 2216, 2217, and 2219 will be pleaded to. Correct?
Yes, Your Honor.
So I'm looking at 1, 2, 3, 4, 5, 6, 7, 8 cases, correct? Or you, Felicia Baker? So you were here with Ms. Mantalini, your attorney, and the state's attorney. Does the defendant waive formal readings of these indictments and the arraignments here? Can we proceed in summary?
Yes, sir. And it just,
So there's one harassment of a public servant and the 7 obstructions.
yes, sir.
Okay,
And they're all third-degree felonies.
and does the defendant waive formal readings of these indictments and arraignments here? Can we proceed in summary?
We can.
In summary, 23, and you are Felicia Beatty?
Yes.
Okay. In summary, 23-2211 alleges that on or about November 12th, 2023 in Jefferson County, Texas, you committed the 3rd-degree felony of harassment of a public servant. Do you understand what you're charged with here? This is a 3rd-degree felony, which means if convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
An agreement's been reached. In your case, you would be pleading guilty, sentenced to 10 years in prison, probated for 10 years, and there would be terms and conditions of probation, normal and customary, and also 3 cases would be dismissed under this agreement. 23 CR 2218, theft from person, 23 CR 2220, obstruction, and 23 CR 2221, harassment of public servant. Is that your understanding of the agreement here? Yes. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
We're going to hold that one in advance just for a second and go to 23 CR 2212, 2213, 2214, 2215, 2216, 2217, and 2219. That should be 7 cases. And again, does the defendant waive formal readings of the indictments and arraignments in each of these cases? Can we proceed in summary?
Yes, sir.
In summary, each of these cases similarly allege the 3rd-degree felony of obstruction or retaliation. In that, in 2212, on or about November 17th, 2023, in Jefferson County, Texas, you committed the 3rd-degree felony of obstruction of a public servant.
And they're all dated the same date. It was one event.
And 23 CR 2213 also alleges on or about November 17th, 2023, you committed a 3rd-degree felony of obstruction or retaliation. 23 2214 also alleges on or about November 17th, 2023 in Jefferson County, Texas, you committed the 3rd-degree felony of obstruction or retaliation. Similarly, in 23 CR 2215, on or about November 17th, 2023, you committed the 3rd-degree felony of obstruction or retaliation. And as well in 23 CR 2216, on or about November 17th, 2023, in Jefferson County, Texas, committing the 3rd-degree felony of obstruction or retaliation. In 23 CR 2217, similarly, on or about November 17th, 2023 in Jefferson County, Texas, committing the 3rd-degree felony of obstruction or retaliation. And in 23 CR 2219, the 3rd-degree felony of obstruction or retaliation, again on or about November 17th, 2023. Each of these involve different victims or complainants who were being obstructed or retaliating against due to their status in lawfully acting as public servants, namely Beaumont police officers. Do you understand what you're charged with in these, all of these 3rd-degree felonies, these 8 that we have discussed?
Sure.
And again, these are, as before, 3rd-degree felonies that you pleaded guilty to or in this harassment in 2211 case of a public servant earlier in this hearing. And in each of these cases, again, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
In each case, in agreement agreements have been reached in each case where you would be pleading guilty, sentenced to 10 years in prison, probated for a period of 10 years in each case to run concurrently. And again, the three cases, 2218, 2220, and 2221 would be dismissed as part of this agreement. Is all of that true and correct? If I follow these agreements in each case, you have no right of appeal of your cases. Do you understand?
Yes.
How do you plead in each of these third-degree felonies, guilty or not guilty? And there's 8 of them here. Are you pleading guilty voluntarily in each case and because you are indeed guilty? Is that yes? Okay. I show you what's marked as State's Exhibit 1 in each case. Did you sign those documents voluntarily? Did you understand them, discuss them with your attorney? Are the contents all true and correct?
You speak a little louder.
State's Exhibit 1, yes? All right. She says yes in each case. And State's Exhibit 1 is admitted in each of these cases without objection.
Objection.
In each of these cases, State's Exhibit 1 states that you've signed, state that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer in each case. All of this is true. It states, so help you God in each case. Is that true?
Yes, sir.
Pre-sentence reports are waived.
Yes, sir.
I'm going to follow these agreements in each of these cases, if nothing further to add, and I will find that you are pleading guilty today, ma'am, voluntarily in each of these cases. You are mentally you understand and appreciate the consequences of pleading guilty. You are mentally competent to enter your pleas of guilty. You understand what you've been charged with in each of these cases. You are giving up your rights to a jury trial and the right to the appearance, confrontation, of cross-examination of witnesses. You are pleading guilty voluntarily, knowingly, intelligently, because you are guilty and you are satisfied with the representation provided by your lawyer in each of these cases. All of this, it states, is true in each case. So help you God. Is that so?
Yes, sir.
And again, pre-sentence reports are waived, correct?
Yes, sir.
I'm going to follow these agreements, if nothing further, and make the following findings in each of these third-degree felonies. You, Felicia Joyce Beatty, are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted in each of these 8 cases to find you guilty beyond a reasonable doubt of these third-degree felonies in each case. I now find you guilty beyond a reasonable doubt in each of these cases. I am following these agreements. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years in each case. Those sentences shall be suspended. You are placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Signing all of this as fast as I can. How long have you been in jail now? You're not just having trouble hearing you all the way
Can you
around.
speak a little louder? December 11.
What'd you say?
December 11. December 11.
Oh, month before last. So
Yes, sir.
you're gonna stay in jail for a while longer. This is a crime wave, is what this is.
67 days.
There will be condition of probation that you serve 150 days
Your Honor,
in the county jail.
if I might, these cases all occurred and she's pled guilty to them all and taking responsibility. But it was just so you'll have a little of a phrase directed at the people at all at one time. And we would ask the court, she's been in jail now for a while. She has, as far as I'm aware of, no recent, do you have any felonies? A long time ago, one? No? Have you got any felonies? She has no felony convictions. We appreciate moving forward without the pre-sentence report, but would ask that you reconsider or hold it in abeyance and give her an opportunity to get started on her probation. And then if the court feels like it's necessary, that order would already be in place.
I feel like it's necessary.
I'm sorry, I can't, you have to speak louder.
You sure you'll have?
Let me know something here.
When is that? If you would consider reducing it, she's going to be the caregiver for her mother who's having surgery on her eyes a little bit later this month, you believe? And she's here in the courtroom,
Who is?
her mom and her support.
Was your mother at the scene of this fiasco event?
I was at the hospital.
Hold on, there's so many cases that you pleaded guilty to that I'm having to go through all of this and make sure that we've dotted all the i's. At approximately 3 a.m, police were dispatched to 4150 Maida Road, Beaumont. You were yelling outside the apartments at 3 a.m, yelling in an excessive volume. Other residents exited their homes to observe the commotion you were making. You threatened to attack this officer along with Officer Davis. And you had a dog with you, and you were using the dog in a threatening manner, apparently. The orders were, you began moving toward other residents who had come out to see the commotion that you were making. The police stated you were erratic in your behavior, yelling profanities and other obscenities. You were obviously a danger. You kept repeating that you had taken methamphetamine. You were incoherent in your speech and behavior. Then you began to spit at the other officers when they were trying to arrest you. Then you told the police when you were brought to the hospital that you have that you had a bullet for the head of a police officer. So you had orally threatened to kill the people. Yeah. Another day in Beaumont of peace and tranquility, and yelling and raving by someone who admits to having drugs, and then threatening behavior. So that clearly reflects that it deserves more than just a little bit of time. You're going to have to serve some time in jail. So
I would just like to add one thing, that although she has pled guilty to the facts of the retaliations by the comment that she made to the officers, and the one where I believe there's a spitting, we don't necessarily agree to everything the way it's depicted in the probable cause affidavit. As I know you lend a lot of credence to that. And if it had gone to trial, maybe some of that would have been correct, or maybe some of it would have been different.
But it didn't go to trial.
But she did plead to making the comment that she made, regardless of all the other descriptive information that is in the probable cause affidavit. And she's taken responsibility for that, and we would ask the court to reconsider this upfront time.
So that's all. She's you're saying because she just pleaded guilty to the yelling at the persons, that should be limited. Is that right?
She pled guilty to the comment that she made in the direction of the officers, which amounted to the elements of retaliation or obstruction. Whether or not she said she was on methamphetamine, she may have said that. Whether or not they felt like she was being whatever with the dog, but what she pled guilty to was the comment that she made.
So you're saying that limited act of hers should not warrant additional jail time.
No, I'm saying that that being a single event and a single phrase, and she's accepted responsibility for that poor behavior, and she has no criminal history that if she to speak of, and she's getting a conviction for every one of these. It's not even an opportunity for deferred. I would ask the court to recognize that she's taking as much responsibility as possible, including convictions, and would ask that you not enforce that.
I'm sorry, over here. I'm sorry. Did the defense completely forget that she pleaded guilty to harassment of a public servant by up to a person she knew to be a public servant, namely a police officer, to contact the saliva she spit at the public servant?
Yeah.
And the complainant was to contact the saliva of the defendant with the Beaumont police officer who was lawfully discharging an official duty. Did y'all? That
No,
wasn't
I
even
included
mentioned
that.
just then.
Yes.
You did not mention that just then.
I did a little earlier. I have acknowledged that, sir. But when I was talking about the collection of the obstruction or retaliation, those were separate, of course. I'm just doing the best I can to try to see if
You
I
said
can
that-
save her from staying in jail.
What the court has to do is to ensure that that the facts are known, and it wasn't, as argued, just some oral statements made in direction of police officers, which is bad enough. She
Retaliation.
spit on somebody.
Yes, sir. And that was,
Okay.
that was
Okay.
the other one by itself.
Now, does anybody feel like being spat upon deserves punishment?
Which was on a different day. That's why they were two different. That was a separate event, but the one with all the obstructions was just the one event. And I didn't want you to be thinking that she was just going on and it yelled at this one and then said that to the other. It was one statement made in front of all of them at one time. So I just want to
I'll
make sure
repeat
you were
once
aware.
again, 150 days in the county jail. You don't treat the people who work for you that way. They deserve more than that. And spitting upon it. I'm sorry. Are you paying attention?
Yeah, I'm paying attention. Yes, I am. But all the truth need to be out there.
Say that again.
I'm not happy about this.
Well, here's what we'll do. We can withdraw your pleas and set these for trial. Okay? Because being unhappy is important. But this is what you just pleaded guilty to under oath. You want to take all of this back? Do you want to take all this back?
And I need to get home.
Ma'am, do you want to take this back? Either tell the truth or not. You either pleaded guilty under oath or not. What do you want? What's your final answer? What's your final answer? Well, if you're unsure, the pleas are withdrawn. We'll set these for withdrawn.
I would
That's
like
all.
the court to consider
That's all. That's
appointing
all.
someone off the
No,
trial list.
ma'am.
Because I'm sure that she would like to have it handled as quick as possible.
All right, it'll be set for trial as soon as possible.
Court ever the opportunity to release me at this point.
You're on trial. We're gonna continue with the representation. That is all. We'll set those for trial as soon as possible. All right, what do we have over here?
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God. So put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in first. He's going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here,